Listen to me very carefully, because what I'm about to tell you has already happened, and most of you do not understand it yet. At 6:23 a.m. Eastern Time on May 11th, 2026, the Supreme Court of the United States issued an emergency ruling that did something nobody in modern American politics believed was actually possible. They struck down every single firearm permit requirement in the country. Not most of them, not the worst of them, every single one. Purchase permits, carry permits, ownership licenses, waiting periods dressed up as safety measures, training mandates dressed up as conditions for permission, all of it gone in one decision. 43 states just lost the primary regulatory tool they have used for 50 years to control who can and cannot exercise a constitutional right. Governors are on emergency calls. Attorneys general are drafting workarounds. Legislation, as I am speaking these words, the gun control industry is having a mathematical breakdown because their entire business model just got declared unconstitutional, and the average American sitting on their couch has absolutely no idea what just happened or what is coming next. I don't care about your feelings on guns. I care about your rights. And right now, your rights just got returned to you. And nobody is going to fight harder to take them back than the people who lost this morning. Before I say another word, hit subscribe right now and drop a comment with the word restored so I know you are awake. I am Warren, your financial combat general, and I do not give you what cable news gives you. Cable news is going to spend the next 72 hours either celebrating this ruling as a libertarian victory or screaming about it as the end of safety. Both of those takes are useless. I am going to give you the cold, hard, mathematical reality of what was decided, what it costs, what the workaround looks like, and what you need to do in the next 30 days before the resistance arrives. Constitutional lawyers charge $800 an hour to walk clients through what I am about to give you in 25 minutes. You are getting it free. Free has a price. The price is engagement. Subscribers stay broke on intelligence. Now let me tell you what actually happened in that courtroom decision, because the language of the ruling is the entire game, and most reporters reading it on television cannot understand it. The case is National Association for Gun Rights versus United States. It arrived as an emergency ruling at 6:23 a.m. Eastern Time. The court's holding is brutally direct. They wrote, and I'm quoting the framework here, the Second Amendment protects a pre-existing individual right, and government cannot condition the exercise of that right on obtaining bureaucratic permission. That is the entire decision compressed into one sentence. Read it again. Government cannot condition the exercise of a constitutional right on obtaining bureaucratic permission. That single sentence destroyed every permit system in America. And the court then drew a line that the gun control industry has spent 50 years trying to blur. They said government can verify eligibility through instant background checks, but verification is not permission. Those two words, verification and permission, are now the legal battlefield for the next decade. A background check that confirms you are not a convicted felon, not under a domestic violence order, not adjudicated mentally incompetent. That is verification, and that survives. A permit system that requires you to apply, wait, pay fees, complete government-mandated training, and receive approval before you can exercise a right. That is permission. And the court just declared every form of it unconstitutional. So let me tell you what died at 6:23 a.m. Massachusetts FID cards, dead. New York pistol permits, dead. Illinois FOID cards, dead. California waiting periods beyond the time it takes to run a background check, dead. New Jersey handgun purchase permits, dead. North Carolina pistol permits, dead. Connecticut licensing, dead. Delaware permits, dead. Rhode Island licenses, dead. Maryland's permitting system, dead. Hawaii's licensing scheme, dead. These were not minor procedural rules. These were the foundation of gun policy in those states, built brick by brick over decades, and they all collapsed simultaneously this morning. The numbers don't lie. Now let me tell you which states are in genuine, full-scale, Capitol-building panic right now, because this is where the real story lives. 25 states already had constitutional carry, meaning they never required permits in the first place, and those states woke up this morning fine. The earthquake hit the other 25, and inside that group, there are 10 states whose entire gun control architecture just got obliterated. Massachusetts is at the top of the list because their system was a two-tier permission structure. You needed an FID card just to own a firearm in your own home, and you needed a separate license to carry it outside, both layers, dead in one ruling. The state spent decades building that system, tens of millions of dollars in administrative costs, and thousands of state employees processing applications. All of it is now unconstitutional infrastructure that has to be dismantled. New York is in equal devastation. Their pistol licensing system was not just a policy, it was a political identity. The discretionary proper cause requirement that let licensing boards reject applications for almost any reason, that exact system the court already partially struck down in Bruin, is now completely gone. You can carry a concealed handgun in New York City as of this morning without anyone's permission. The NYPD licensing division is preparing for layoffs. As I am speaking, Illinois lost the FOID card system, which was not just a permit, it was a registry, a database of every gun owner in the state. That is the part that should genuinely matter to you, because that database now serves no legal purpose under federal law. Constitutional law, California's 10-day waiting period, which forced citizens to wait nearly 2 weeks after a background check cleared before taking possession of a firearm they had already paid for, gone. New Jersey, Connecticut, Maryland, Delaware, Rhode Island, Hawaii, all of these states built gun control as a centerpiece of their state identity, and all of them woke up this morning constitutionally naked. The cost of administering these systems across the affected states runs into the hundreds of millions of dollars annually. That is hundreds of millions of taxpayer dollars now sitting on a balance sheet attached to programs that no longer have legal authority to function. You are broke and you do not even know it, because that money was coming out of your paycheck for 50 years. Now, I need you to understand what is coming next, because if you think this ruling is the end of the story, you are not paying attention to how government actually behaves. Every governor, every attorney general, every state legislator, and every restricted state is right now in an emergency meeting asking exactly one question: how do we do this under a different name? That is not cynicism. That is documented institutional behavior. When you eliminate a power structure, the people who built their careers on that structure do not disappear. They transform, they rebrand, they find new legal language to accomplish the same objective. Every Town for Gun Safety just announced a $50 million campaign for what they are calling alternative public safety frameworks. The Brady campaign is circulating internal strategy memos right now, exploring what they openly call permission equivalent verification systems. Read that phrase one more time. Permission equivalent verification systems. They are explicitly looking for ways to recreate the permission structure while calling it verification, because verification is the only category of regulation the court left standing. The workaround playbook is already written. Massachusetts will announce an owner verification certificate that takes 60 days to process and costs $300. California will propose a comprehensive background check registry that functions identically to the system that just died. New York will introduce ownership documentation requirements that look exactly like the pistol permit they lost. Illinois will rename the FOID card into something with different letters and try to keep the database alive. The names will change. The functions will not. And this is where the cold mathematical reality of constitutional law kicks in. The court's ruling does not care what you call it. The principle the court established is that any system functioning as permission, any system that delays the exercise of a right, any system that gives government discretion to deny that right, is unconstitutional. Call it a permit, call it a license, call it a verification certificate, call it an eligibility documentation framework. If it functions as permission, it dies in the next round of litigation. And that next round of litigation is coming faster than any state legislature can prepare for, because the Second Amendment Foundation, the Firearms Policy Coalition, and Gun Owners of America have already filed pre-positioned legal challenges against every workaround pattern they anticipated the states would try. Now stop and understand how we got here, because this did not happen by accident. This is the culmination of 18 years of methodical constitutional construction. And if you do not understand the buildup, you do not understand why the ruling this morning is so brutally final. In 2008, the Supreme Court decided Heller versus District of Columbia. That ruling established for the first time in modern constitutional history that the Second Amendment protects an individual right, not a collective militia right. It was a massive shift, but Heller left an enormous loophole. The court said states could still impose reasonable regulations. Nobody knew what reasonable meant. And that single word became the legal battlefield for the next 15 years. In 2010, the court decided McDonald versus Chicago, which incorporated the Second Amendment against the states. That meant states could not ban handguns outright, but the reasonable regulations language survived, which meant permit systems, waiting periods, and licensing requirements all stayed in place. The right existed on paper. The infrastructure of denial existed in practice. That was the status quo for 16 years. Then in 2022, the court decided Bruen versus New York. Bruen is a case that secretly built the foundation for what happened this morning. The court established what is now called the historical tradition test. From the moment Bruen was decided, any gun regulation in America has to be consistent with the historical tradition of firearm regulation as it existed in 1791, when the Bill of Rights was ratified, in 1868, when the 14th Amendment was ratified. If your regulation does not have roots in that historical period, it is unconstitutional. This morning, the court applied that test to permit systems and found exactly what every honest historian already knew. Permit systems for private firearm ownership did not exist in 1791. They did not exist in 1868. They are entirely modern inventions designed to control access to a constitutional right. The mathematical logic is undeniable. If a regulation has no historical tradition, it fails the Bruen test. If it fails the Bruen test, it is unconstitutional. Every permit system in America has no historical tradition. Therefore, every permit system in America is unconstitutional. The court simply did the math that the gun control industry has spent decades pretending does not exist. Now, here is what you do in the next 30 days, because intelligence without action is just expensive entertainment. Step 1, verify your own eligibility. This ruling did not change federal prohibitions. If you have a felony conviction, an active restraining order, a mental health adjudication by a court, or a drug abuse adjudication, you are still prohibited. Background checks still work. The court explicitly preserved them. Step 2, if you are eligible, exercise the right, walk into a gun store, pass the background check, walk out. You can carry concealed in public nationwide as of this morning. Without a permit, without permission, without bureaucratic approval. Step 3, document everything. Receipts, background check approvals, timestamps, store records, keep every piece of paper. Because when a state launches its workaround legislation and starts charging citizens with violating the new systems they are about to invent, documentation is the legal foundation of your defense. Step 4, respect the sensitive places, restrictions, because the court did not eliminate those federal buildings, schools, courts, airports. Those bans still apply, and they are still enforceable. Do not test them. Step 5, get voluntary training. Government can no longer mandate training as a condition of your rights, but that does not mean training is unnecessary. It means it is your responsibility. Now, competence used to be the government's excuse to gatekeep your rights. Now, competence is your job. Welcome to actual freedom. Step 6, support the litigation, because every state that resists this ruling will be sued, and every lawsuit costs money. The Second Amendment Foundation, the Firearms Policy Coalition, and Gun Owners of America spent millions of dollars over a decade to win this morning's ruling. They will spend tens of millions more defending it over the next 5 years. They need resources, they need members, they need legal support, and here is the cold political math you need to internalize. Before the 2026 election cycle gets serious, this ruling exists because 3 justices appointed by one administration shifted the constitutional balance of the Supreme Court. If the next presidential administration appoints replacements with different philosophies, this ruling could be partially or completely reversed within 10 years. That is not partisan commentary. That is the documented reality of how the Supreme Court functions. Your rights are now downstream of your voting behavior. Vote like your constitutional rights depend on it, because mathematically they do. So here's the question, and I want a real answer. Are you going to be a winner, or are you going to be a loser? Are you going to take this intelligence, the ruling, the workaround strategy, the 6-step plan, the political math, and actually act on it? Or are you going to scroll to the next video, forget what I told you within an hour, and find out 6 months from now that your state quietly passed a new permission? system under a new name while you were not paying attention. Winners stay informed, losers stay surprised. The Supreme Court just handed 180 million American adults the practical ability to exercise a constitutional right without government permission. That ability survives or dies based on whether the people who hold it actually defend it. Subscribe to this channel. Share this video with one person who needs to wake up, and drop a comment telling me which workaround you think your state tries first: registration, certificates, or ammunition licensing, because the numbers don't lie, cash is trash, and the permission slip is finally dead. Make sure it stays that way.